I think one of the biggest challenges, the landlord's waiting a little too long to file the case. If you have a promise from the tenant to move out in 30 days, you should check with them every week and actually do a visit. Are they boxing up their apartment? If you're not seeing movement by the resident, serve them with the notice, get the case going. At a minimum, you get the case filed, you agree, hey, I'll dismiss the case in 30 days if you're out. So that's one thing to be mindful of, is filing a little faster and paying attention to whether or not they're really moving. Welcome to another episode of the Straight Up Chicago Investor Podcast. I'm your guest, Tom Raleigh, and with me as always is your hosts, Tom and Mark.
All right. That's as loud as we're going to get them. We'll take it.
Yep, for sure.
You know what? It's good to know if you have an attorney going to try to settle up payment plans or whatever, he's not going to lose his calm and start screaming at someone. So I'll take that as it's a good thing to have.
Oh, man, that's awesome.
Man, I think it's the longest gap we've had between having a guest come back.
Yeah.
4 years or more.
It was episode 40, right?
Yes.
Yeah, that's technically an OG right there.
Yeah, there we go. Man, what else you got going on right now?
It was my birthday today, so that's...
You know what? I knew that, and then I forgot about it, and now happy birthday.
Okay.
By the way, this is not your birthday when everyone's listening to it, so that makes it confusing.
Well, let's see who's going to be the first person that's going to text me happy birthday 30 days from now. I'll send you a T-shirt.
All right. Again, not a straight-up Chicago T-shirt, just a T-shirt that Mark owns.
Just a white tee.
Yeah, just... We give weird gifts over here. So... All right. Well, happy birthday, sir.
Thank you.
Actually, I remember you had, I'm trying to think how old you are, because you had your 40th when our first year or two of this. Are you 42?
Oh, man, 44.
44. Man,
We're year 5, dude.
We've been doing this a while, yeah.
Yeah. So
Man.
I was only 19 when we started this. Or 19, 39.
19. We're all over the board here. So
I love when people say, today I turned 30 for the 14th time.
Yeah, there you go. Well, my wife lies about her age to a point where I have to back into all right, you were born in this year. No, this is how old you are.
My wife's older, so it doesn't come up that often when it comes to. She doesn't bring up my age ever because she doesn't want her age to reflect.
Oh, there you go. So, all right, let's enough of this tomfoolery. Let's get in here. What's the housing provider tip of the week?
All right, so today we're going to talk a lot about the eviction process, and the best way to prevent eviction is to make sure you have a solid tenant screening on the front end. We're going to talk a lot today about just following a process and making sure you're getting everything in there, because there's a lot of risk. There's a lot of risk on the back end. So if you're a landlord and you're not prepared or you don't have a proper screening process, then reach out to me. Reach out to a company like us that you can even hire us. You don't have to hire somebody to handle everything, but at least get that screening part right. Get that tenant placement in there, because I'll tell you this: if you get the tenant part right, the rest of being a landlord ends up being fairly easy. So we're going to talk about this a lot today, and we're going to talk about other options you have as well too. But if you're going to get anything right, get the tenant screening process right.
Yeah, I mean, real estate works. Just don't F it up.
Yeah.
Right? This works. Been proven to work. All right, let's bring our guest in.
All right, today's guest, back from episode 40. He's what I always refer to as the #1 eviction attorney in Chicago, and he created the architecture around the payment plan that we definitely use here at GC. And without further ado, want to bring in Tom Raleigh. Tom, welcome.
Yeah, good to be here, guys. Thanks for having me.
You came out to the underground. The last one was Zoom, which I watched that recording prior to today, and we've came a long way. So I'm
I was in a different house.
Yeah.
In the background,
yeah. I had my COVID haircut. I thought I was growing it out at age 40 still.
We all have our COVID haircuts, man. That's good.
Yeah. So, man, your world never ceases to be simple or easy. What's going on in your world these days?
A lot is going on. We'll say this, that evictions has become a big topic for a lot of landlords, whether it's in your world or my world. And I would say what's at the top of everybody's mind is, why the hell are evictions taking as long as they are today? I know you guys had me on for a few things. At our firm, we handle building violations. Evictions is our primary, and that's what we're going to probably spend a lot of time on today. But I will say, just jump into a story right away. I think this just hits hits home for me and some others in the industry right now. So we take on cases either from small, medium, or large landlords. This particular landlord was based in Chicago. She had a single-family home on Western and Cullerton. She called up our firm, said, "Hey, Tom, I've got a problem. I've got the city of Chicago writing me on my property because we rented to someone. They use fraudulent methodology to get into the unit, and they are gangsters. They came in with it was a husband and wife scenario, and lo and behold, they're not married, and lo and behold, one of the guys is in one of the gangs. She sent me the file. It was a termination notice as well as a letter from the city of Chicago saying, hey, you got to get this resident out. I told her, as bad as this is, they're selling drugs, they're causing crime, they're impacting other families and children on the street. We're going to move as fast as we can during the process. Before I dive into kind of what happened next, let's just go back to pre-COVID days when eviction court systems were arguably relatively fast to cut.
Relatively
fast. Relatively fast. Back in 2018, 2019, we get in and out of an eviction case in 60 days. And the reason we grew our practice so quickly is because we were really efficient. We would actually get in front of the tenant before our court date. We'd actually be able to talk to him in court. We'd actually, on the first time we were up, we'd go into a little side room, say, hey, ma'am, or hi, sir, what's going on? Why are you here? What can we do to help you? We'd either get him on a move-out agreement, say, hey, let's forgive and forget, or we'd put him on a payment plan. That worked well. We were able to be face-to-face, understand what their pain points were, and really almost become a mediator between the landlord and tenant, even though we represent the landlord. Worked well. Today, fast forward to today's world, let's call it 2021 to current, these things are now, instead of taking 60 days, are taking closer to 6 months. Some faster, some longer. That's what you should be expecting. The reason that is, every case is going through what's called an early resolution program. So you file a case on Jan 1, you're stuck, it takes you about 45 days just to get to court on your first court date. And then when you're on the 45th day, 30 days automatically given to the tenant to go seek free legal aid. That typically fails 95% of the time, and then it's transferred to a trial room. That's what we're up against today in terms of the speed.
We have to highlight, though, that the serving doesn't have to be done by the Cook County Sheriff anymore. Like, we gotta
we'll
celebrate
get
some
there.
wins.
And we'll get there. We'll talk about
Okay.
the good, but let's talk about the ugly first.
Okay.
This case, again, individual owner, this is their only property. So it's really important for anybody to understand that this is a major impact. If that's one of your sources of income as an individual, this is more meaningful than if you are a large operator and this is part of the you kind of underwrite this as part of your business. So it becomes very personal. So we were able to update her throughout the case. We got into court within 45 days, but the tenant showed up and they got their free legal opportunity to speak to free legal aid. Nothing happened. Again, 95% usually don't settle in those courtrooms. It's basically a big delay tactic. It has good intentions, but doesn't work out like that. It then got transferred. We're now 2 months in, still no eviction order. We tell the judge, hey, we have a letter from the city of Chicago. We have to work with them to get them out. It's a drug and gang enforcement agency. We have to work through them. They're telling us to get them out as fast as possible. Judges say, hey, I'm bound by these, the court rules. I'm going to have to, I can't prove this case up today. We're going to move you to a trial room. That takes 3 weeks to get reassigned. Now we're 75 days in with nothing. And then we get to our trial room. And on the day of trial, it was all via Zoom, by the way. We step up, and I see a blank screen. And we're the last ones called in this court. There may be 20 cases up that day. And it's like, Tom Raleigh, step up. I'm like, Judge, I see a blank number, and I happen to see the last name. It looks like one of the individuals on the, one of the named occupants on an email that we share with the client. I want you to notate the file, because if we go to trial today, I want them to see that they participated. Judge asked them to turn the screen on. No one appeared, so we did our prove up. We had our client there. Did you serve this? Did I still live there? Do we need an eviction order? Yes. We basically got through our line of questions. The eviction order was ruled in our favor. The landlord was able to place it with the sheriff, and sure enough, and a lot of landlords and some attorneys may not know this, but if you get your eviction order and the defendant or tenant doesn't participate in the case at that very moment, it's called a default eviction order. And every defendant in those cases has an automatic right to vacate the 30-day eviction. So that I told the judge that's what's going to happen, and sure enough, 2 weeks later, we saw a motion filed. Fortunately, that judge remembered the case. I marked it, he marked it, and he basically denied their motion, even though they had opportunity, because he said, tenant, you've been here before. You've been here 3 times in the case. You had your trial date. You missed it. I'm going to still stand by my word and get the eviction order to the landlord. That all took 4.5 months to get through that case.
Let me confirm there, because you move fast in that. So if I don't show up, I have how many days to come back and actually bring it back to court?
You have 30-day automatic right to bring it back to court.
So they can wait to 27, 28, 29, file for it, and then court's not for another.
2 to 3 weeks from that door. And then you got to prove up your case again if your eviction order is vacated.
So it just becomes a game then for the
It
tenants.
is a
in that
game.
sense.
We're seeing a lot of the defendants and counsel for the defendants waiting to the, day 20 to 25 to file those motions. And it's obvious what's happening there. It's a little frustrating, and we deal with it. We pay attention to it. We make arguments, and hopefully the judges start seeing these trends because they're picking up.
I have used that for building court though over at Superior, where you got 21 days to come back. And I have used it there though, so I'm partially
Day 20?
guilty. Yeah, I'm partially guilty. Not eviction court though.
So that's the story. We ended up getting the resident out. The client was really happy, but that gives you a sense of, even though I have the city behind me as my supporter, to get a violent criminal or someone that's selling drugs out of the property, it's still taking months to get them out, and that I think needs to be restructured, relooked at.
Well, that's after they got served.
That's
That could have taken another.
It could have taken.
It takes 30 days to realize, all right, this is bad. Another couple, it could take a day, it could take weeks to actually serve.
Yeah.
Right? Like it's the whole overall
your-
timeline is still 6 months there.
Most of your mom and pop landlords don't even know what to do at that point. Like,
Yeah, they call and just
do I call? Do I get a form online? Like
That's right.
or they probably mess up. I probably managed. You see a lot of people mess that part up right there. Even
We see a lot of mess ups. We typically, the mom and pops are trying to do these things on their own, and we do recommend you at least get a consult before you file your case. There's a lot of tricks in there, a lot of challenges. It used to be able to show up to court in person, and it was just easier. Everything now is remote. Everybody's. I want to picture the Brady Bunch for those that remember that show. In our first court dates with these ERP rooms, it's all hosted in one room. Imagine the Brady Bunch, the opening scene, but multiply that by 200 people, and multiply that opening scene by 3 hours. You typically have 200 to 300 cases being called in a single room, and being managed by 2 judges. It's pretty wild stuff to watch. Yeah.
So that sucks, right? Things are taking a long time. As a housing provider, what are some things I can do to just minimize the damage, to make this go as quickly as possible?
Yeah.
The things that I can control.
I think one of the biggest challenges, and I'm not sure if it's a problem, but it's something I would recognize and I see more common, is the landlord's waiting a little too long to file the case. Because I might just be able to get this tenant out. There's a couple things we could talk about here, but one thing would be like, if you have a promise from the tenant to move out in 30 days, you should check with them every week and actually do a visit. Are they boxing up their apartment? Did you have a sample of a lease? Because people typically like to sign a lease in advance. Let's get that. Let's see that. If you're not seeing movement by the resident, serve them with the notice, get the case going. At a minimum, you get the case filed. You agree, hey, I'll dismiss the case in 30 days if you're out, and I'll get it off your record. But then you have something in exchange for getting them out. So that's one thing to be mindful of, is filing a little faster and paying attention to whether or not they're really moving. Second, cash or keys is your friend. If an eviction is going to take 3 to 7 months to do, and you know what the cost is, the timeline, and your rent is $2,000 a month, you know what you're losing every month. You can back into a number that's reasonable to get them out. Tenants know how long it's taking to do the eviction, so they might require a higher number. It used to be $500 to $1,000 to get someone out with cash or keys. It's now $1,500 to $3,000 depending on the market. So cash or keys is your friend, and making sure you get those things in writing is a component to that.
And there's the brain damage, like the going to sleep at night knowing like this person's out, right?
That's
Like
right.
just
That's right.
the peace of mind.
that was an extreme scenario with gang members and all that stuff, but the average person just has payment problems, and you're the founding architect of court-ordered payment plans in my eyes.
Right.
I always paint that picture, but does that mean to you that at day 6 they should be filing, or like how? Like I always tell people that there's this fine line when makes sense for a tenant to keep paying you versus it's cheaper for them to not pay you anymore and figure out their
Right.
next plans in life.
Let's say it's before court and it's you talking to your tenant and say, hey, you owe 1 month's rent. It's day 20. Where is the rent? You're having those conversations already in month 1. Month 2, if they've fallen behind, they're going to start, hey, I'm going to pay you everything in 2 weeks. And everything in 2 weeks is the red flag for us. We want to see if the balance is $2,000 at that point, let's say $1,000 per month is the rent. I would like for them to make a good faith payment now. I don't care what your situation is. I want a good faith payment. I don't care if that money, that first payment is $50, $100, $200, but that initial good faith payment that you're asking for, that you want this Friday, is a way to indicate whether or not they're serious. If they're willing to lay down $100 or $200 just to get the ball rolling, at that point, when you're in front of them, meeting with them, that's the time you break out a payment plan and say, hey, look, if you don't pay this back over a period of X, we are filing the case. Here's your 5-day notice. And that's how we typically like to see that structured. But the problem with those internal payment plans with you and the tenant, there's no teeth. There's zero teeth to them. So what we like to do, what you indicated, which is get to court and get them structured on what's called a court order probation order. So you file your case, you're in court, we're talking with them on a phone call or on a Zoom meeting. You say, hey, ma'am or sir, you owe X, how do we get to start paying down? At that point, they have something to lose because if we structure something where rent is due on the 1st and let's call it another payment by the middle of the month until this balance is paid down in 3 or 4 months, if they miss that payment, we have a right per that agreed order to go back to court and say, hey, judge, this was missed. We're entitled to an eviction order. The benefit of that is not just getting on this payment plan, but now I'm not waiting 6 months for that final trial date. I've settled it on month 1 or 2. They missed that payment right away. I get my eviction order. They waived their right to trial. They waived their right to jury, and it's a true agreement where you almost want the tenant to succeed, but now you have an opportunity to get your eviction order a little faster if the tenant's just playing games, and that's what we like to see in today's court.
How long does it take to bring it back to court if they break a payment plan?
Here's what we do. So if we enter an agreed order, say today, we typically kick it out in court 2 weeks out to get that good faith payment. That good faith payment, again, is a little higher, typically in that $400 to $500 range. If they miss that payment, we're already in court. So the payment's due on, let's say, 2 weeks from today. We're in court in 2 weeks plus an extra few days to make sure that payment clears. And that when we're up in judge, say, judge, the tenant paid or didn't pay. If they made that payment, we then dismiss it, and it's back to the landlord. Say, hey, you manage these payments. And it might take them 6 months to pay it down. But and in that case, if it's back to you guys and they miss it, it takes about 2 weeks to get back to court to get the eviction order. So not a lot of lost time.
Man, I love that program just because it ends up being a win-win. Now, maybe the tenant ran some issues. Now you're forced to work with the tenant, but the tenant now has an eviction filed on them. And at the same time, they probably don't want to move or have the funds to go do it anyways. And you're actually giving them an opportunity. And if the owner could maybe even just recoup half the money, if not, maybe save them. I know for a while we were tracking it. We had like an 80% retention. If we went into the payment plan,
yeah, you guys are rocking.
We were retaining them, and it was huge.
Well, that's gonna just weed out who's playing games and who's had on a hard time.
Yep.
Right? It's hard times. Like that person will at least show the effort to claw out, as opposed to the person who's like quote unquote given up. Like I'm never gonna pay you, and I'm gonna ride this out.
It's funny you're saying that. It's like we had one client early on. They had about 1,000 doors. Like, what if we just, upon signing a lease, we just sent them to eviction court before they were even late and just got them on a structured pay and stay into perpetuity. And I said, that's just going to cost you way too, like it's going to cost a lot of time and energy. And quite frankly, save your money, wait till they default and then go into court. But it's
improve your screening.
Yeah, I mean, we can talk about that too today. We should talk about improving your screening, what you guys are doing, what we're doing, and all the things other landlords are good practices. But yeah, evictions are a beast. They are challenging. They are tough. But with all the ugly, there is a little bit of good news we talked about before we started this podcast fired it up. But another good piece of information that came through January 1st of this year, there was a new law that passed. And this is a little bit too much in the weeds, but allows at the top level our clients to save about $100 per filing. So what ends up happening before, when we filed a case, you'd pay your $500 to the county. And part of that, $120 went to the county, went to the sheriff of Cook County. We'd always have to pay them first. They wanted, their piece of the pie, and we'd have to use them to try to serve the complaint and summons to get the tenant to court. That costs time and money. If the sheriff failed, which they had a success rate of maybe 23%.
23%.
So it's pretty low. It's pretty low. Other markets it's higher, but in our market it's 20 to 30%. On the lower end of that, where our process servers that we are private and we hire them and we, challenge them. We actually track our service rates and see how successful. And I'll call them up. Hey, Brian or Joe, you guys are lower, you guys are higher, great job. We hold everybody accountable. The sheriff now has, under this new law, is no longer part of the required process to get tenants served. What that means for us and our owners is we file the case, we can skip the sheriff, we pay them $5 to basically thank you, and then we go right to our process server. So all those savings, instead of paying the sheriff, we use that to, that goes back in the pocket of our clients. We get to court a little faster, and we save you guys money. So it's a benefit to everybody.
The funniest part about that, like how that came to be, was the time it took between they're going to do it and it went live. And I talked to somebody at the sheriff's office. They struggled to figure out how to get the $5 from one pot to the sheriff's pot. That's right. Like, that was like the delay of like they couldn't just like figure out a reconciliation on a monthly basis, write the check over. Like it literally, they're like, well, I think this passed like in May or something like that. We're like, well, we just do January 1st. We got plenty of time to figure this out.
Yeah.
Like that was the.
Well, I'll tell you what, I think the sheriff's office is actually based on, I think they're happy about it. I think there was a challenge, and you look at
Manpower for sure.
Yeah, manpower is a big thing. No matter what, if we work for the county or for the sheriff's office or for the clerk's office, there is a manpower issue. They will admit it. They'll say, hey, we're hiring new people. We're getting new talent. Bear with us. And they've been doing that for the last 2 years. And we're starting to see the benefit of a lot of people left during COVID, but a lot of people have come back and starting to work, and they're starting to build their team out. And we're starting to see again, a little bit processing of orders and documents and filings. And we hope to see a cleaner 2025, much cleaner 2026.
Nice. All right, you came prepared with a ton of stats. Let's roll in.
Jump
I won't even
into
ask
it.
you a preface question.
Okay.
Just go ahead and lead the way.
Sure. So this is data. So this is data of evictions we filed between 2021 and 2024. So January 1st, 2021, all the way through past Christmas of 2024.
Wow, so that's great.
Yeah, it's a lot of data. We just did a giant Excel dump. I did this morning. There's about 10,000 cases filed. So it's not a small data point. I wanted to know.
So you guys are filing like 3,000 a year?
It's about that. Wow. It's a lot. It's a lot. I first started in 2013. I got excited when we did maybe 30 filings a month. I was just super, super stoked. I'm like, oh my God, I'm really doing this. And now we have an incredible team. We have a team, a lot of them are remote, even 2 from Philippines, and they're rock stars. Absolute rock. We can talk about that later, but that's been a fun thing that we're doing. But anyhow, 10,000 cases filed. Of the cases, I wanted to look at what was important to me is there a trend anywhere? And one of the trends that I saw was, what were the balances when we filed the case? So if you send me a 5-day notice and you're like, hey, Tom, we served this month, they owe, call it X amount of money. What is that balance upon file date? In 2021, the balance was really high. It was $6,500. Let's say, and typically 3X is what people are filing off of, which we'll mention here too. 2022 went down by 1,000 to 5,500. 2023 it went up, is 5,000, and it stayed pretty firm about 45 to 5,000 balanced upon filing. That's all relative. The rent could be 2,000, could be 1,000, but just back into it's about 3X people are waiting. I would like to see, and what we advise our clients to do, coming from your guys' world, I was a landlord in operations first and became an attorney. What we like to understand is drawing a line in the sand and saying, hey, here are the rules on what your filing balance should be. It was 1.5X or 1.75 extra balance. So if your rent is $1,000 a month, we'd always recommend that you filing in the middle of the month as soon as the balance eclipses $1,500 in an example. We're seeing landlords just waiting a little too long. And the reason it's more impactful today than it was before is if I file a case on January 1st, by the time they're gone, it's 6X more after you file. So you're carrying a balance maybe of 7 to 9 months.
Yeah, minimize it on the front end.
So I'm not saying send it to your attorney right away, but damn it, do your diligence immediately to see if they're willing to pay right away or if they're willing to move out. And that's a visitation to them directly. Like, go visit the tenant, go really see what the reality is before you send it to your attorney. But don't wait 3 to 4 months before you send it to your attorney. That is a huge difference between 2019 to today. So the balance has come down, but it's flat at 5,000. I should have done pre-COVID numbers, say what was the balance upon COVID, pre-COVID. But we hope to see this trend come down. Like I said, what are our clients filing? It's like a little over 3X the rent. That was surprising to me when I pulled that.
Real quick to interrupt though, it is good. It is going down, and rents have increased a lot.
That's right.
So it is actually probably decreasing a little bit at a little bit better clip.
Yeah,
That makes sense.
That's right. I would agree with that. The zip codes. I was curious. What are the most common zip codes? Now, data is not perfect because some of my clients might have a cluster of properties in certain areas, but I have a pretty broad stroke of who we're working with. It could be, anywhere from Humboldt to the north side, the west side, the south side. So it's important to understand that this is a pretty wide spectrum, but South Shore, 60649 was by far our number one filing zone. 60619 was our second, that's Calumet and Chatham, and 60637 was another one, also South Austin. These are massive areas.
So 37 ends up being just Woodlawn, all the way down to Deering.
Yeah.
Like,
So
it's all everywhere around South Shore, basically.
Yep, and the number one street that we filed, I did a text to column, function. South Michigan was a big one. South Drexel and South Central, and South Kingston rounded out the fourth. So those are challenging, not just zip codes, but even more challenging streets. So if you're listening, double check your underwriting on those 4 streets.
Yeah, we managed something on all 4 of those.
It's tough, man.
Yeah.
It is really tough. What other stuff? I did look, and this kind of ties into our payment plan, so I'll mention this here, but let's say the 2024 cases, around 3,000 cases, you've got, and stuff's still pending, so again, it's not accurate, but it's just a quick snapshot. About 300 cases, multiple clients have applied for rental assistance, but only 300 cases of the 3,000 have been approved.
So
or
10%?
been used. Yeah, it's a very small amount. There could be another 20 to 30 pending. I just don't know. We are seeing this take a very long time to process. So it's taking so long that you may have applied for 10K, but by the time you get there, the balance is 13K. And what do you do with that 3,000? Because as soon as you get approved, you're supposed to dismiss your eviction case by law. So a lot of our clients, I'll just take the 10,000, serve them a new 5-day, and get it back into court, for the balance. But what I don't like to see today, if rental assistance were being approved in a month or 2 weeks, this would be easier for all of us, and the strategies would be much easier. Like, let's just get the rental assistance and move on. But because of the length of time it's taking, and the inability for that program to understand why the length of time of processing those is actually negatively impacting the resident, we had to re-strategize our approach. And back in May of earlier this year, we're like, we want and I did this for my personal buildings myself, I want my tenants to have skin in the game. So I'm willing to apply with my resident for rental assistance as long as they sign my agreed order. My agreed order states, look, I'm behind in rent. I agree my balance is $5,000. I promise to pay my rent every month until we get a decision. And if it's approved, great, my balance didn't grow. You get all your back rent back and your 500 filing costs. But if I'm declined, we implement, we keep the pay and stay in place, but now it triggers the arrearage payment. And for the listeners, the arrearage payment is anything that's, let's say your balance is $5,000 at the time we get the decision. We're going to spread that $5,000 over 10 months to make it manageable. And they're going to be paying rent on the 1st, $500 on the 15th. That actually protects the tenant, that protects our client, and it's almost a win-win, whether it's approved or declined.
That really protects you think resident advocacy people would love that. That's great.
You'd be surprised. So we recommend that to every tenant advocacy program. They go tell us to go fly a kite. We're not going to put our tenant in jeopardy, but they don't quite understand that this is going to take another 3 to 4 months, and their balance just accumulates. But why not get the tenants, if they are employed and they are able to pay, why not use that opportunity to get back on track and at least get the muscle memory back of what it's like paying rent again, right? And that's what we're up against. There are, 5 or 6 people in charge of that program that are on the same page in terms of this is a benefit for everybody. Quite frankly, in my personal opinion, this is just my personal opinion, it benefits very few, and it's not coming fast enough for other landlords to trust it. So when the trust is being tarnished, you got less and less landlords applying, and 5 of my clients have just said, just don't do it. We don't want to see it. I don't want to sign any more documents. Either pay or get out.
Is it a manpower issue between the time I apply and the time I
would imagine that's it. I would imagine that's it. I would say there's something going on where you apply for rental assistance and then you apply through the portal. The tenant gets the email, you get the email, you fill out your packages, you submit your complaint and summons, you submit the ledger, you submit whatever you need to submit, and you followed all the guidelines, but then you keep getting in review. Like you're missing this document, and you keep submitting the same document 4 or 5 times. I'm hearing that a lot. So a takeaway from that is keep submitting the documents, email them on a regular basis, and pay attention to your own email. What's happening? I bet a lot of these.
We're so scared to miss that email.
Yeah.
Like it's so sensitive.
Yeah.
Like you miss that
You
email.
have to get and pay attention to your email. A lot of mom and pops are not paying attention to email, like running it and like hawking their email. You gotta just be on top of it. Make sure you attach your email to your phone so you're seeing a bunch of stuff come through. So it's a problem.
With the CARES Act, is that going away? Are you seeing issues
It's
around
not
30
going away.
versus
So-
5 days?
So out of the good news of your costs coming down, the bad news is the CARES Act, and again, for your audience, the CARES Act was passed during COVID to address so many COVID-related issues. And one of those COVID-related issues was how do we help residents that are unemployed going through a challenging time in COVID, they can't find employment or can't pay their rent. And that CARES Act basically said if you have a Fannie or Freddie Mac loan on your property, or it's subsidized by some federal, the resident itself is subsidized by the program, you have to give them more time to pay rent. And that what would used to be a 5-day notice for non-payment turned into a 30-day notice for non-payment. We were all hoping that once CARES Act went away, and it did, everything would sunset with it. But the only issue with that is the eviction section or the housing section didn't sunset. In Colorado, I believe Colorado reaffirmed at the appellate level that's here to stay. So unless Congress gets involved and from a federal level it goes away, you're kind of stuck with. So again, 5-day notice for those residents that are non-Fannie Freddie Mac buildings that are market rate, just normal paying residents without any subsidies. 30-day notice goes to those buildings or tenants in a building with Fannie Freddie, and or have a CHA or HACC subsidy.
Man, this is so important. I think a lot of people don't realize this. Like, I have to guess you back out people that own stuff free and clear. I mean, I imagine 70% of these loans are your conventional type loans, or you have Section 8 tenant. I'm making up that number, but would you guys agree? Like, it's got to be a pretty high percentage.
I would say definitely the house hackers for sure.
Yeah, and
like
every house
everyone who owns that 2-4 unit. Then I would say a lot of like those, and then it almost like flips like the bigger guys who have like the $5 million loan. That's Freddie,
Yeah,
Fannie,
yeah.
and then like the
FHA stuff is that's
and then like in the middle, like the stuff that I have is more like commercial in-house stuff.
So with that 30-day notice, obviously we were talking about timelines. Like, do you just give that, maybe way earlier, 6th, 7th day? And then I believe there's some way you can write that. You could probably advise us. You could write it on there where it actually accounts for the next month's rent, because by the time that expires, you're actually into the next month.
Yeah. So if you serve a 30-day, let's say their tenant, let's say it's a CHA resident, it's a $1,000 voucher, and the tenant of that whole voucher, the tenant pays $300 a month. You serve that 30-day notice on them. One, you can only serve on their portion. Let's say
That's a good point.
CHA's.
That's a good point.
Just say CHA is just late on the payment. You can only include the tenant's portion, or else it's a violation of the rules. You have a chance to get your case dismissed. But assuming you served it correctly in person and they have a balance of 300, I guess your question was more along, will the balance continue to accrue? Is that your question? Or?
Is there any way to write that 30-day notice where the February rent is actually?
You can't get in front of it, so you can't ask for rent that's coming due in the future, which is not a bad idea, but you can't.
Because think
do
about it, if you deliver that, even if you're like, all right, grace period's 5th, deliver the 30-day notice on the 6th, and then now it's February 6th, and they might have paid January rent, but now you're back starting over
Right.
again.
That is the challenge, is that as soon as they cure, whether you're a market rate or a subsidy tenant, as long as if you pay $1 of that balance, you're supposed to reserve them a notice, right? It's so a lot of times if you take $1, let's say $10, tenant pays half that, you might want to return the money and get to court faster. But there's no easy way to get out of that 30-day issue. It's just part of doing business. So if you underwrite subsidy, you are going to get higher rents. I'm seeing, and you're actually seeing this, starting to see pops of CHA and HAC. They're starting to catch up with the inflation and starting to pay more for the landlord. So it's becoming more, appetizing to play into that space. But with that, you have annual or biannual inspections. You typically have more larger families in your properties for that, and you typically have to wait longer to get to court. So there are some benefits and challenges with subsidy type residents.
Is CARES Act like it's solidified into law going forward, or is there a chance it could still be?
I don't see it going away. Yeah, I think it's here into perpetuity.
Yeah. Almost everything we've talked about has been for non-payment of rent. Can we hit on, you have a tenant that's a danger to the building, right? You have someone who's causing, they're harassing, they're attacking another tenant.
The drug dealer that pays their rent.
Yeah.
They pay well, don't they?
Yeah. Like that.
They pay ahead. Yeah, they pay ahead in advance.
That person. So like, how do you go, for someone who hasn't been through that, how do you go through that eviction process?
Yes, there are two other, let's just go through the other three examples. Easy one is a squatter notice. That is someone that breaks through the back door or got into the unit without your permission, simply put. There are laws coming into place, we think, in 2026 that might pass that allows you to use local enforcement for trespassing to actually get them out. I just don't know when that's going to happen. But squatter notice is a simple notice. You serve the squatter. You don't even need another name. And you serve it today. You can file the case tomorrow. Easy. The other one is a non-renewal. Let's say the tenant's been there for a minute. They pay their rent every month, but maybe they're just not as good, and maybe you want to rehab the unit, maybe you want to turn into a 2-bedroom from a 1-bedroom. You can serve a non-renewal notice. There's two types. There is what's called a 60-day notice or a 120. 60 is if they lived in the property for under 3 years. You serve it on January 15th. That thing would expire March 31st. If you serve a 120-day notice, that would be for those residents or families that lived there for over 3 years. So they've kind of broken those up. What they're doing there is trying to not have landlords come in, take a 2-flat, kick them all out within a month, and start rehabbing the unit. And there's good intent there, and I kind of agree with that. People can't move as quickly as you'd all want them to. There's resource constraints, job issues, school issues, all things we all want to take into play, into mind as operators.
That notice isn't bad.
No.
That's one very dealable. The only time that notice sucks is when you forget to serve it. You're like, oh damn, now we got to start 120 days.
Real, just a tacticality on this thing. If you move into the next month, it's not like an extra day. It's a whole nother 30 days, right? Am I articulating that correctly?
Yeah, so
can you articulate it the right way?
If I serve a notice on January 15th or January 20th or January 5th, it doesn't matter.
That's February 1st.
If you serve it on January, it's going to expire the last day of the month it expires. So here's how I work it in my head. It's probably not the easiest way to understand, but if I serve it on January 15th, in my head, I'm like, all right, that's March 15th. But then I fast forward to the end of the month to make it your final termination date. So that's the math I'm doing in my head every time I talk to a client. January 15th, I serve it. January 20th, all right. March 20th, I know it would expire, but by the law, you got to extend it to the final day of that month for it to be effective.
Correct. So if you had done it February 1st instead of January 29th,
that's right.
You go another 30 days.
Right.
Missing that 3 days costs you 30 days.
So then you would argue that it would expire April 1st, right? But it could you have to fast forward it and extend it to the final day of that month. So it'd be the last day of April.
Correct. Which is a big deal. If this is a troubled tenant, right? If it's just like a renewal or whatever, not a big deal. But if it's a troubled tenant that you're trying to get out, you've just cost yourself another month of it.
We run into issues where people want to sell, and now all of a sudden that puts them into September or October. Mm-hmm. Just kind of the season kills
and my
us with
client,
that stuff.
I can tell you, clients get really frustrated when I review it. I'm like, and they wait to send to the 60th day, and it's like it terminates the wrong date or too early or whatever. It's demoralizing to them. But we'll help you out if you want to ever give us a call. We'll walk you through it. The final category is for a 10-day notice for cause. Let's talk Chicago specifically. 10-day notice for cause would be tenant has too many dogs or unauthorized pets or unauthorized occupants or too much activity going on. They're hanging out in the common areas. Maybe they're smoking too many cigarettes or something like that. It's have an impact on the rest of your families or kids in the building. Violence it's an endless list. We're seeing more and more of those today. But what I would say is you in that 10-day notice you have to identify basically the date of the activity. Let's say they have too many dogs. So on January 15th, I walked to your unit. I saw you had 8 dogs in the unit, and we only allow with written permission. You have 10 days to get rid of all your dogs. they don't, you file your case. So you got to point out, again, the date that you saw the activity, the actual activity, and you have to speak to the actual violation of the lease. Now, if you don't have a lease, some of these are month to month or oral or verbal leases. They're just been there for 5 years. You have nothing on file. You can point to the RLTO, Residential Landlord Tenant Ordinance, to indicate whether or not they're in violation of something. And we've seen some of those come through. But yeah, those are the categories: non-payment, non-renewal, squatter, and for cause.
Is the 10-day more of a stick than it is? I mean, how many people are you evicting on that?
We have seen an increase, and I don't have the numbers on that one, but
so you're doing these on a regular
we are
basis.
doing these on a regular basis nowadays. We are creating them on a regular basis nowadays, and some clients, to your point, use them as, hey, let me just I don't have any intent of filing it, but we do think it's a good behavioral tactic. And one thing we'll add to that is,
Yeah, you want them to just stop doing the behavior and let them know you mean business.
Like,
Yeah,
just get back to where we started.
and you also can attach, as long as your lease structure this, when landlords, when they have a lease, you should have a structured fines and rules and regulations. So in the event that you violate it, you can serve with a 10-day, and you can put a fine on their ledger. And then they say, hey, finally, I'm gonna not put my kids' toys down the toilet and keep clogging toilets. And they say, fine, we're just gonna waive this fine, and everybody wins, because now their behavior's been improved. They know that the next time they're actually going to get fined, and you feel good because you've reduced the fine and they're back on track. And so we do like to see that, less of a filing tactic, but a lot of our operators use that to train and reiterate what's important to their their properties and how they manage them.
Cool. What else? Anything else our listeners should know? We covered a lot here.
We did. Yeah, we have a seminar called a webinar coming up on March 13th. It'll be myself, an individual at a company called Rent Butter, which is a software screening company.
Well, I was going to ask you that next. We'll get you that plug.
And then the third person is someone that Mark and I know that basically works at Fair Housing. So the topic of the webinar will be resident screening best practices, technology to get in front of fraud, and like your top 5 to 10 questions of how the hell am I supposed to screen and not get in trouble? And that's, how do I handle immigration, ITINs, how do I handle, source of income questions? Because we are starting to see a huge trend of issues with resident screening, fair housing complaints, stuff like that. We see at least a few a month. And we help advise on that. And that kind of maybe segues in nicely into our next topic, which could be, whatever you guys want to
So with Rent Butter, when you were on, it was 4 years ago, we were said, hey, coming in 2021. So it's kind of cool that now, here we are.
Yeah. The reason we started that one is, I mentioned this in the first podcast, was you typically, and you guys are seeing this firsthand, there are a lot of good, people applying for an apartment that have low credit scores. Maybe in that 500 range, 600 range, like, man, that just doesn't meet my credit metric. I want everybody 675 or above with the credit FICO score 675 or above. Anybody else, I just want to ignore. But what we're starting to see with that software company we designed and developed was to help those that actually have really good financial behavior, but their credit score doesn't reflect it. We all know FICO is really designed for lending, mortgages, big time loans, and operators shouldn't really be using FICO. It's a really good baseline, but there's more to someone's financial history. Some of those things would be, how much, what's their number of inquiries on their background. They have a giant surge of payday loan inquiries. That could be a red flag, right? Or if they have a giant surge of bad debt. Bad debt alone is not a bad thing. But when you see, I might have a medical bill from 10 years ago I just didn't even know about, or school debt, and people have a lot of that. But if you see it flatline, that's a good trend. But if you see surges in behavior and you actually add timestamps to their data, that's what our product does. It adds timestamps. It allows you to see from a behavioral perspective what's happening. So what Rent Butter was designed to do, it helps landlords understand and find good residents no matter their credit score. And that's what the space that we're in on a day-to-day basis in eviction court. Family had an eviction 10 years ago, maybe not an eviction court again, but they had eviction 10 years ago. They've improved. When I was 21 versus today, a different person, or when I was 31 to today, different person. It's a big difference, and I think you're starting to see a trend of better software, better technology, better data to help give operators a line of sight of how this person is going to perform over the next 9 to 16 months. So that's what the software does, and we're really proud of what we've done. I no longer manage that from day to day. I stepped out, and we have another great guy, Chris Rankin, that manages a software platform. He's rocking and rolling, and we're a nationwide product, plugging into several software systems, and whether it's an AppFolio integration or Yardi type integration, allows landlords to plug it in and really understand who they're renting to.
That's great, because here it's so funny, because ultimately you could sit there and say the goal of the software is to work you out of a job. But you know damn well you're never going to get worked out of a job because there's so many people that don't do the shit they're supposed to do. Like,
That's right. And when I went out,
There's some accountability there. Then you can hire him for the evictions. Like, hold on, this was your software said.
You hit it something. So when we went out and pitched and raised money on this product, and we did it during COVID, but my law firm was all but shut down. It's like you couldn't evict, you couldn't do anything. I'm like, oh, I'm bored. I'm going to do something. So we're going to start this software company with my partner, and I went into these meetings to go raise some money, and I'd say, what's my background eviction? He's like, well, what about? I'm like, if I can put my eviction business out of business, I've just solved a massive problem. And now that's a nationwide problem, and I'm going to be much happier solving that than doing the day-to-day eviction work. And I think that sold a lot of people on the story, the belief, our systems that we're putting into place. And fast forward today, it's now in a lot of manufactured housing operators, a lot of low-income housing operators, a lot of workforce housing operators, because they understand that we are looking in a very gray area, anywhere from 500 to 650. A lot of their tenants are all in that spot. Like, how do you differentiate someone from in that gray area? And we allow different data sets to show through, to shine through, to say, all right, they might be both 575, but this one's performing much better.
Yeah, because if I'm just going to simplify it, it's taking into account where they are today. You're overemphasizing the recentality of it compared to 5 years ago, and just whatever other trends you're pulling out from there. Is that accurate? Or?
That's right. Yeah. What Rent Butter is doing, it allows you to, I don't really care, what your ability is to pay rent. Everybody on paper has the ability. I make $3,000, my rent's $1,000. I had the ability to pay rent. What we're looking at is willingness to pay rent in addition to ability. So willingness is what a lot of scientists will call grit factor. When things get really rough, can you get out of that hole? Do you have enough resources in your life to get out of those holes? And those are the things we're looking at, really, is willingness and ability, not just ability.
Yeah, that's awesome.
We were talking before the show about the fair housing letters that landlords are getting on the rise. You're representing some of them. Any general tips you might give the landlords out there just to avoid getting those letters? I think sometimes they just happen, but...
Yeah. One, come to the webinar March 13th.
Okay.
Look out for that. But two, what's really hard as an attorney is, since beginning of time in my days at Pangea, it was, hey, treat everybody the same that's coming through the door. Don't make any exceptions, because as soon as you make an exception, you're in trouble. Fast forward 10 years. We are in today's world. I still try to promote that. Treat everybody the same. Apply your metrics, whether it's credit score, eviction look back, criminal back, and we could talk about criminal data too. But make sure you plug in your metrics or have your metrics written down so you can tie everybody to the same decision making. What's happening today is what this little thing called disparate impact. Disparate impact basically says, among the other factors, which is like fair housing, which is other issues like source of income. You guys know all that, some of those things. But with disparate impact, it says, even if you have the same metrics and you're applying the same decision-making metrics to everybody coming through your door, some of those metrics ultimately might hinder a certain class of people or a certain race of people. And if it has a negative impact on a large group of people, you're supposed to actually individualize your assessment. And so what used to be pretty easy in black and white, it's like, I want nothing less than a 600 credit score, no evictions in the last 5 years, no major credit card issues, car loans are paid, those metrics. Now you have to say, all right, I can't always look, if they come through and someone is right at your 650 credit score, are seeing letters that credit scores now shouldn't be your baseline. Now there's no absolute law on these things yet. And I think it's going to unfold over the next 3 years of how do landlords freaking operate and stay out of trouble? And so I don't have a really clear-cut answer. I would say that you should have your metrics in place. And you should also at the same time make an individualized assessment if someone's on the fringe. Let's give one example, a real life example, if I can come up with one. But let's use something that, you and I talked about before the podcast. If you could walk us through, what that, example was.
The one that you and me worked out together?
Yeah.
Oh, so we had a tenant that applied, and she was a rural housing tenant in DuPage County, and basically, our under 600 you get denied. And she had a couple other things on there as well too, which ultimately made us, when we looked at it closer, we just couldn't do anything about it. But we ended up getting a letter from from a tenant rights advocacy out of Wheaton, basically saying that her income is Section 8. They'll be able to pay. There's no better guarantee than Uncle Sam. Like, she shouldn't be judged based on her credit score. So it's like that went against everything that I've ever known to be true of. Keep everything exactly the same, because if you don't, you'll get in trouble. And we ended up having.
Now you're discriminating the other way.
Yeah, well,
right?
Right. Well, I thought about it in that moment. I'm like, all right, so we just denied a whole bunch of other people that had the above credit score that might have had one or two other things that could have probably been less riskier than that particular applicant. Where it's like, so we had to get a letter. I had to call up Tom, and we had to work on it. Like, it was
yeah,
crazy.
and it ended up working out okay. We had a recommendation to people out there is don't hide from these letters. I would say, either hire an attorney or just call up the housing advocate and the resident advocate and say, hey, look, here's what we're looking to. Here's our metrics. Help me understand what you guys are really looking for us to do.
Do you have someone else who meets this?
Well, that was the biggest, that was the biggest part of that call that we took away. Was I think you and me spent an hour on the phone with her, but it was more of understanding, like, hey, how can we bridge this gap, and how can we create a win-win here for ultimately to create housing for everybody and make sure everyone has the equal opportunity. Because the call started off as like us defending ourselves, but it sounds like you had some great relationships with our tenants. You guys doing some stuff together, but. That's the thing right now is we're all trying to figure out how
we all want to comply.
Yeah,
we just want
to
comply. I mean, no one's out here trying to like be secretive about it. We just want to comply, rent to good families that pay the rent. It's really that simple.
You told us to have criteria follow. We're doing that. Okay, now it's moving. So how should we do it where we can all be on the same page? Like that's
right.
That's we want people in our place paying rents, and you guys supposedly have people or tenants that you represent that can pay rents, and it should be it should just be so simple, right?
Right.
Like
it should be a roadmap on how we handle these things, and no one's given us a roadmap. And you almost got to get, burned once before you start really looking at this individualized assessments. Again, that's where the trend is going. It's like you're supposed to treat everybody the same, but you also want you to individualize their background history and say, it's really challenging.
Well, I think it was Jared's episode, but he talked about we began this episode talking about how long it takes to evict. And saying if you can fix that, and let's say that becomes 30 days, 60 days, something like, maybe a red state, like he'd be willing to take more shots, right? You'd be willing, that person who's like, man, this might not meet it, but like, whatever, like you'd be willing to slide a little bit more. But it's just the downfall is so heavy and so hard that it becomes almost impossible to ever lower your standards. Yeah, because the risk is, I'll take another month of vacancy. Like I will wait until, which I think is the right approach in
and think
today's
about
market.
this. In addition to that, security deposits. We would love to take security deposits and take maybe a 2x security deposit. It's a little higher risk because we have a backstop. We have a little security. But now there's so many people who've gotten sued so many times that we can't take a security deposit anymore. So you got to take a measly old moving fee and just get through that. And that's just not enough to kind of offset the risk. So I think the advocates have good intentions, but if we just gave these advocates their own home each to rent, they would understand what we're going through and how we have to deal with it, and why a lot of the things they're doing doesn't make a lot of sense long term. Short term, sure, on paper that looks good, but reality is just talk to housing providers. And say, hey, look, what do you guys think about these laws and rules? How would you guys view those? And you hit it on the head. The harder it is for me to screen. And you're like, I'm just going to wait for the perfect tenant. Same time, if I could just backstop this with the two-month security deposit, I might take that risk. But they're closing the doors on residents without knowing they're doing it.
Yeah.
Or the worst thing that could happen for this whole conversation is you get so discouraged by the system, you get so discouraged by what you're trying to jump through, or you think the risk is too high, you sell it to an owner-occupant. You took a whole other rental out of the system.
That's right.
Yeah.
We're seeing actually more and more of that. Like they're like, I can't really handle these 6-month evictions. I'm getting out.
Yeah.
I've seen a lot of our clients, and another fear I have is like the mom and pop owners that are using this as income, and they have a bad apple or maybe 2 bad apples on a 2-flat. They're not getting rent for a year. That's a challenge, and they're going to start passing management off to other people or just sell their property altogether. And then the bigger guys gobble it up. Nothing wrong with that, but it does create an imbalance of what the city really believes in. Like we want smaller mom and pops own businesses and to run their properties. And quite frankly, the only people that can handle this type of risk and this type of bad debt are the larger operators, because you can put all that bad debt and kind of share it amongst your properties versus one property. And again, people are not taking those extremely important details into account. It's frustrating.
Yep. All right. Good stuff. Let's wrap here.
Cool. All right. What's your competitive advantage? How have you been able to do all of this while others wish they could?
Yeah, we've 10x here since we talked to you.
Yeah. So I'll tell you what. We start early. I'm an early riser and I'm an early finisher. I get up early and I get home quick and try to get a balance of life that I didn't have before. That's a big part, because if I'm getting my sleep and I'm working out and I'm eating well again. During COVID I was like running 2 businesses. It was too tough, but now I've been able to kind of lighten the load a little bit. Just having a better balance is a big part of that. So that's my answer on that one. But.
Yep. All right. What's the one piece of advice you would tell someone that is yet to buy their first property here in the Chicagoland area?
Don't buy on South Michigan, South Drexel, South Central, South Kingston, or these zip codes.
Good bring back.
All right. That's going to be the answer. That's awesome.
Yeah.
All right. So what do you do for fun?
What do I do for fun? You know what? Gosh. I'm a podcast listener. I do try to work out 2 to 3 times a week. And I do like to travel. It's particularly in the wintertime in Chicago. So we're just in Mexico with my wife and kids. 2 weeks ago, it wasn't long enough, so we're going back next weekend. And then we plan to get out of the city of Chicago every month, at least for a weekend, until it warms back up.
Yep.
Get some sun.
All right. What's a good book, podcast, or self-development activity you'd recommend to our listeners?
Meditations is a book that I've just cracked open last week. Let's see if I finish it, but that's when I started. And it's podcast-wise. This is I'm listening to some more political stuff just to get a little bit more smart, but more centered stuff that I'm listening to. And Breaking Points is one of those that I'm listening to. I think it's pretty good. It's got a left and right speaker. And then I also have gotten into, I don't know if you guys have heard of it, the Sean Ryan Show, which is a combination of military tech, technology, some politics, which I find, someone friend recommended that, and I thought that was a good.
Yeah, I've never listened to that, but I've heard him on other podcasts.
Yeah, he's good.
All right. Other than yourself, name a valuable resource for other Chicago investors.
As you scale, I think there is a resource that our law firm just learned about, which is hiring nearshore or offshore. Typically, you can actually hire a really, really awesome person, in our case, from the Philippines, for about $18,000 to $20,000 a year, and they are freaking rock stars. They are, working our hours, Central Time Zone, so they're working at like 10 o'clock at night to 4 in the morning, but they're really happy to do it. They're excited to get a paycheck, and we really like working with them. So that's something we just started using in the last 6 months. We're really happy to share.
Well, we got on our homepage. We had Pete Newberg on here a couple dozen episodes ago, where if for his company, that's all he does is offshoring. Any straight up Chicago investor listeners get a $250 discount on their placement or whatever if they sign up through the website.
Yeah, and you guys have it on here at GC. I've used them for data scrubbing, for phone calls.
It's
like
awesome. It's awesome.
Yeah, we got 30 in total. Like, it's great.
Yeah.
Yep. All right, awesome, Tom. Thank you so much. You provide a ton of value to our listeners. How can they learn more about you? Is there any way they can provide value to you?
Yeah. Well, how they provide value to me?
Yeah.
I guess just go to our website, halstedlawgroup.com, and set up an inquiry, and we'll call you back within a day.
All right, so we'll link to that in the show notes. We end with our Chicago fact. Mark, who are we playing for? Who is our sponsor?
All right, playing for Jason Kane, who bought a sweatshirt off a straight up Chicago investor merch store. His sponsor is Mike Procaccio. So, Jason, if Tom or myself gets this question right, you get a $50 gift card brought to you by Mike Procaccio from the Pro Financial Group.
So, all right. So, we got a fellow Illini here, but I didn't even do an Illini question. Also found out he went to Bennett, which is in the ESCC, our conference that I was in as well. So, here's your question. So
I'm not going to get this
Dave
right.
Bickler also went to Bennett Academy. He's the lead singer of this band that wrote Eye of the Tiger for Rocky 3. So it's really not even Chicago. Who wrote Eye of the Tiger? And your options are Survivor, Supertramp, Boston, or REO Speedwagon. Who wrote Eye of the Tiger? Had no idea.
Big one.
List out those names. Can I phone a friend?
Survivor, Supertramp, Boston, REO Speedwagon.
Shoot.
I'll go with Boston.
I'll go with REO just for the.
Oh, come on, guys. Survivor. Come on. Thought we'd have that one.
Let's roll that back.
I had no idea he was a Chicago guy.
I didn't know that either. Oh man, that's awesome.
He also did, I didn't know this, but doing the research, remember those Bud Light Real Men of Genius commercials from like the 90s?
Yeah.
He was the voice of that.
Oh.
So the guy did Eye of the Tiger and that. Those are his 2 claims of fame. Good life.
My son asked me why I get so excited when that comes on and then the other Rocky song. So like, you just got to be over 40 to understand, kid. All right. Well, sorry, Jason. We'll put your name back in the hat and get another opportunity to be part of the Chicago Facts. But thank you for going on the Straight Up Chicago merch store and buying something. We're looking to do a 5-year party. We're celebrating 5 years here in May. So if anyone has any ideas out there or venues or themes, like do something crazy, we're open to feedback from the community. So let us know. Send us a message. Thanks for coming on here, Tom. Thanks as always, Tom. Listeners, we'll see you next week.